Welcome back to the deep dive. We are exploring how something seemingly minor, like violating a traffic law or a local ordinance, can suddenly become a huge deal in a civil lawsuit.
Yeah, we usually think, okay, it's just a small fine. But in civil court, that same violation can sometimes be the key thing that proves negligence. Today, we're diving deep into this doctrine called negligence per se. Uh, so to get us started, think about this. Driver D is driving at night but forgets their headlights. That's against the law, right? They hit driver P. Now D gets a ticket, pays the fine. But what happens when P sues D for negligence? How does that forgotten headlight, that criminal infraction, play into the civil case?
Right. That's exactly where negligence per se, or NTS, comes in. It's basically a shortcut for the plaintiff. For P, in your example, normally P would have to argue that D wasn't acting like a reasonably prudent person, and that standard, well, it could be pretty,
That's less.
open to debate. But NPS lets the court say, hold on, the legislature already decided what's reasonable here. Turn on your headlights. So the court can adopt that specific law, the headlight statute, as the standard of care. Ah, okay. So it replaces that general reasonable person idea with a hard and fast rule from the law.
Precisely. And if the court adopts the statute and the violation wasn't excused somehow, then boom, the violation is the breach of duty. Plaintiff P still needs to prove causation and damages, mind you, but the breach part, that's settled.
Wow, okay. That gives a criminal law a lot of weight in a civil case. So, who gets to decide if a particular statute should even be used like this? Is it the judge, the jury, and what's the criteria?
It's entirely up to the judge. They're the gatekeeper here. And the first thing they look at is the statute specific enough?
What do you mean specific?
Well, a law that just says drive carefully or use prudence, that's too vague. It doesn't really add anything concrete to the usual reasonable person standard.
But why not? If the law says be careful, shouldn't that count?
Because it doesn't give specific guidance. The power of NPS comes from statutes that tell you exactly what to do or not do, like stop at red lights, or keep animals in pens, or don't exceed 30 miles per hour, something concrete. If the statute is specific enough, then the judge applies a really important two-part test.
Okay, what's the test?
Two key questions. First, was the statute designed to protect against the particular type of harm that the plaintiff actually suffered? And second, is the plaintiff part of the class of persons the statute was intended to protect?
Type of harm, class of persons. Got it. Both have to be met.
Both. If either one fails, the statute can't be used for NPS. The plaintiff just has to argue the regular reasonable person standard.
All right, this two-part test sounds crucial. Let's analyze the first element, the type of harm. We can use that classic case, Goris v. Scott. First, what are the legally dispositive facts?
Okay, Goris. The plaintiff had shipped some livestock, sheep, and cattle on the defendant's ship. During the trip, there was a storm, and sadly, the animals were washed overboard and drowned. The plaintiff sued, pointing to a law called the Contagious Diseases Act, which required ship owners to keep animals in specific pens during transport. The defendant hadn't done that.
And what was the core legal issue?
The precise question for the court was this Contagious Diseases Act, the part requiring pens, actually designed to prevent this kind of harm, animals drowning or being washed overboard? Could it set the standard of care here?
What rule of law did the court apply? Can you state the full black-letter rule and break down its elements for us?
Sure. The court applied the basic NPS adoption rule we just talked about. It says a statute can set the standard of care only if two conditions are met. The elements are: one, the statute must be designed to protect against the proper type of harm that actually happened, and two, the victim must be within the proper protected class the statute aims to shield.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, proper type of harm?
Well, the court looked closely at the Contagious Diseases Act. What was its purpose? As the name suggests, it was about preventing the spread of disease among animals packed onto ships. It was a sanitation measure.
Ah, so the pens weren't really for safety from storms, but for keeping sick animals away from healthy ones.
Exactly. The court reasoned that the law's goal was disease prevention, not preventing livestock from, drowning or washing away in rough seas. The harm the plaintiff suffered, property loss due to drowning, wasn't the type of harm the statute was aimed at preventing.
So even if the defendant had built the pens according to the law, it wouldn't necessarily have stopped the animals from being washed overboard in that storm.
That's the point. Compliance wouldn't have prevented this specific accident. Because the harm suffered, drowning, didn't match the statute's purpose, disease control, the court concluded that the first element, proper type of harm, was not met.
And after analyzing the elements, what was the court's final conclusion?
The court refused to adopt the statute. The plaintiff couldn't use the violation of the Contagious Diseases Act to automatically prove breach of duty. They had to fall back on arguing that the defendant failed to act as a reasonably prudent ship owner under the circumstances. The violation itself was irrelevant to this injury. Goris really highlights that tight connection needed between the harm and the statute's specific purpose.
Okay, that definitely clarifies the type of harm element. It does set a pretty high bar. Now, things get really interesting, I think, when we look at the second element. The class of persons the statute is meant to protect. This comes up a lot with those key in the ignition laws.
Absolutely. Those laws fine drivers for leaving keys in unattended cars, mainly to deter theft.
Right. So let's say a court decides the purpose of such a law is safety protecting the public from injuries caused by car thieves driving recklessly. That handles the type of harm. But what about the class of persons? Let's use the facts of Rushing v. Gerstheimer here. What happened?
Okay, in Rushing, the defendant violated one of these ordinances, left their car unattended with the keys inside. The plaintiff was actually a mental patient who had wandered off from a nearby hospital. He found the car, stole it, went for a joyride, and then crashed, injuring himself.
So the person suing was the unauthorized user, the thief himself.
Yes, exactly. The person who took the car and got hurt.
And what was the core legal issue?
The legal question was, does the protected class of a key in the ignition statute, even if we assume it has a safety purpose, include the unauthorized user of the car, the person who stole it and then injured themselves?
What rule of law did the court apply? Still the same two-part NTS adoption rule, I assume.
Correct. The rule still requires both. One, proper type of harm, injury from a car crash, which arguably fits a safety purpose, and two, proper protected class. The focus here shifts heavily to that second element.
Okay, now for the court's elemental analysis. Let's focus on the second element, proper protected class. How did the court figure out who the law was trying to protect?
This is where courts have some leeway, interpreting legislative intent. The court here decided that the primary purpose of these key in the ignition laws is to protect the general public, pedestrians, other drivers, from potential harm caused by the thief's negligent driving.
So it's designed to protect innocent bystanders from the thief.
Precisely. The court reasoned it was definitely not intended to protect the thief himself from his own actions, his own bad driving after stealing the car. To let the thief use the statute would, frankly, seem absurd, rewarding the wrongdoer.
Even considering the plaintiff was a mental patient, did that factor in?
It was part of the facts, but the court's analysis focused on the role, unauthorized user. They determined the class protected by the statute was the innocent public, not the person who violated other laws by taking the car in the first place. So the plaintiff fell outside that protected class.
And after analyzing the elements, what was the court's final conclusion?
The court refused to adopt the statute for NPS purposes. The injured patient, the unauthorized user, couldn't use the defendant's violation of the key in ignition law to establish negligence automatically. He'd have to prove regular negligence, which would be tough. It's a great example of the protected class element acting as a common sense filter.
Okay, so the rule seems strict violation equals breach, but life isn't always clear-cut. What if someone violates a law for, well, a really good reason? Like, say there's a law, stay in your lane. But a driver swerves into the oncoming lane to avoid hitting a child who just darted into the road. Are they automatically negligent per se for crossing the line?
That's a fantastic question, and it highlights a crucial safety valve in the doctrine. If we applied NPS rigidly there, the driver would be negligent per se. They violated the statute.
Which seems totally unfair.
Exactly. Early courts sometimes did apply it that literally, leading to harsh results.
Yeah.
But modern courts recognize excused statutory violations.
An excuse. Okay, how does that work?
If the defendant can show a legally recognized excuse for the violation, then the statute is effectively ignored for NPS purposes. The case just reverts back to the standard reasonable person analysis.
And what counts as a valid excuse? Swerving to miss the child seems like one.
Absolutely. That falls under the excuse where compliance would involve a greater danger than the violation. Saving the child is clearly less dangerous than rigidly staying in the lane. Other common excuses include things like a sudden emergency, not of the driver's own making, like hitting unexpected black ice, or the person either knows nor should know they need to comply, maybe like a tail light suddenly burning out without warning, or incapacity like a sudden heart attack, or simply being unable to comply despite reasonable efforts.
So if the violation is excused, the NPS shortcut is off the table.
Correct. And often, the reason for the excuse, like swerving to miss the child, also demonstrates that the driver was acting reasonably under the circumstances anyway. So an excuse often leads to the defendant winning under the regular RPP standard too.
Got it. That makes the doctrine feel a bit more flexible. Now, let's talk about some specific situations, some exceptions maybe. What about licensing laws? Say someone's driver's license expired yesterday. They're a great driver, very careful, but they get into a minor fender bender. Can the other person use the lack of a valid license to claim negligence per se?
That's a common question, and generally the answer is no. Most courts refuse to apply NPS based solely on the violation of a licensing statute.
Why is that? It's still breaking a law.
The reasoning is that licensing laws are usually about ensuring a minimum level of skill before someone undertakes an activity, or maybe they're for raising revenue. They aren't typically dictating the specific conduct required moment to moment while performing the activity. Think about it.
Yeah.
If we allowed NPS just for lacking the license, you could have a world-class surgeon performing an operation perfectly. But if their license lapsed and something unrelated went wrong, they could be found negligent per se just because of the paperwork. That seems wrong.
Right, that disconnects the violation from the actual careless conduct, if any.
Exactly. So, the plaintiff still has to prove that the unlicensed person was actually negligent in their actions, that they lacked the proper skill or failed to exercise due care, not just that they were missing the piece of paper.
Okay, that makes sense. Prevents form over substance. What about children? We know they're usually held to a different standard, like what's reasonable for a child of that age and experience. Does NPS override that? If a child violates a safety statute, say, darts out on a bike without looking, are they automatically negligent per se?
Another great point. The general consensus among courts is no, the child standard of care prevails. The law recognizes that children have different capacities for judgment and understanding rules. So while the fact that the child violated the statute might be evidence that they were careless, it doesn't automatically establish breach like it might for an adult. The jury still primarily considers whether the child acted reasonably for a child of similar age, intelligence, and experience.
Unless they're doing something like driving a car.
Right. The exception is usually if the child is engaged in an inherently adult activity, things like driving a car, a motorcycle, maybe a speedboat. In those cases, they're often held to the adult standard of care, and NPS could potentially apply.
Okay, one more angle. What about the flip side? Someone complies perfectly with the statute. Let's say the law requires using hazard lights when stopped on the shoulder. Driver pulls over in dense fog, puts on the hazards exactly as required. Does that automatically mean they exercise due care? Can they say, hey, I followed the law, I'm not negligent?
That's a trap defendants sometimes fall into. The rule is clear. Compliance with a statute is merely relevant evidence of reasonableness. It does not automatically establish due care.
So following the law isn't always enough.
Not always. The statute usually sets the minimum standard of care. A reasonably prudent person, facing particular circumstances like that really dense fog you mentioned, might need to do more than the statute requires. Maybe they should have pulled further off the road or tried to get the car completely out of the way, or maybe even get out and wave traffic away if safe. Just turning on the flashers while compliant might still be considered negligent if the conditions demanded extra precautions. The statute is a floor, not a ceiling, for safety.
Wow. Compliance is just evidence, but violation can be conclusive breach. That's quite an asymmetry. Okay, we've covered a lot, the basic rule, the judge's test, the cases, excuses, exceptions. For our listeners, maybe law students facing an exam or practitioners spotting an issue, can you synthesize this into a kind of step-by-step framework for analyzing an NPS problem?
Absolutely. Having a clear diagnostic checklist is key. Here's how you should approach it. Step 1, spot the issue. First, just identify that there's been a violation of some kind of statute, ordinance, or regulation involved in the facts. Step 2, threshold test. Ask, is this statute specific enough to even be considered for NPS? Or is it too vague, like drive safely? If vague, stop here. NPS doesn't apply. Use the RPP standard. Step 3, adoption test. Element 1, protected class. If specific, then ask, is the plaintiff within the class of persons this statute was actually designed to protect? Think Rishink, was it meant for the general public or the rule breaker themselves? Step 4, adoption test. Element 2, type of harm. Next, ask, was the harm the plaintiff suffered the specific type of harm this statute was intended to prevent? Think Goris disease control versus drowning. Step 5, role of excuse. Okay, let's say both adoption elements are met. Now ask, was the defendant's violation excused? Was there an emergency? Would compliance have been more dangerous? If yes, the excuse cancels NPS and you revert to RPP analysis. Step 6, consequence. If the statute is specific, The plaintiff is in the protected class. The harm is the right type, and the violation was unexcused. Then you have negligence per se. The violation is the breach of duty. But remember,
Still got to prove causation and damages, right?
exactly. MPS only establishes breach. The plaintiff still needs to connect that breach to their actual injuries and prove the extent of those damages.
That framework is incredibly helpful. It really structures the analysis, but it also highlights, as you said earlier, how much power this puts in the judge's hands, determining whether to adopt the statute based on those first two elements.
It does, and that's where the main criticism of the doctrine comes from. Critics argue it allows judges to effectively create massive civil liability stemming from what might be a very minor infraction, something the legislature only intended a small fine for, like a $50 parking ticket, suddenly becoming the basis for a huge damages award.
Yeah, it feels like the court is almost rewriting the penalty the legislature chose.
That's the argument, that it potentially usurps the legislative role.
Ah.
And by taking the breach question away from the jury in many cases, it shifts a lot of power from the jury to the judge, deciding as a matter of law whether conduct was unreasonable simply because it violated a statute. It's efficient, maybe promotes safety, but it definitely raises questions about judicial power and the jury's traditional function.
The sheer impact of a judge deciding to adopt a statute is striking. A minor infraction becomes potentially devastating civilly. It really underscores that obeying even small rules isn't just about avoiding a ticket. It's about avoiding potentially massive liability. And that leaves us with a final thought for you, our listeners, to chew on. Given that the legislature often explicitly sets a specific, often minor penalty for violating a statute, is it appropriate for a court to essentially override that legislative judgment by using the violation itself as automatic proof of negligence in a completely separate civil lawsuit? Where should that line be drawn? Something to think about next time you see those traffic signs.